Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're discussing a newly introduced piece of legislation, Bill C-63, the Online Harms Act. This bill does a variety of different things that strangely don't seem to be directly related to one another. The bill would create a digital safety commission and impose a duty on social media platforms to act responsibly. This involves developing digital safety plans and creates heightened reporting for takedown for child sexual abuse imagery and revenge porn for internet service providers. Bill C-63 also amends the criminal code to create new hate crime offenses and increases the maximum sentences for hate speech. It also amends the Canadian Human Rights Act to introduce the previously repealed Section 13, which allowed for a civil remedy for hate speech. This bill does a lot, and civil liberties advocates have raised some concerns that parts of the legislation, especially around hate speech, which can be amorphous and subjective. Here today to discuss this bill are two experts, Professor Michael Geist of the University of Ottawa and Josh DeHaas, counsel for the charity I work for, the Canadian Constitution Foundation. Thank you both so much for joining me today. Now, as I said, this bill does a lot, so let's go through some of these different parts of it individually, starting with this Digital Safety Commission. Professor Geist, can you explain what this commission, this new regulator, is and what types of content it's concerned with?
Sure. So I mean, the government has established, as you mentioned, this Online Harms Act, which deals with seven harms. We can get into those harms in particular, and I think understandably there is need to have some kind of enforcement mechanism. The focus of this part of the bill is by and large the responsibilities of the large internet platforms. What are they required to do to mitigate some of those harms? And if I guess I'm assuming that the government looked at the landscape and said, well, the CRTC, the Broadcast and Telecom Regulator, is not a suitable place to do this. The government itself is certainly not a suitable place. You'd have real concerns about the government itself issuing these kinds of orders. So I think there was, in fairness, a need to establish a new form of regulator, and this would be the Digital Safety Commission. I think, and we can get into it, there have been some concerns expressed around the kinds of powers that they have, whether or not there's sufficient oversight associated with it. So I think its existence is likely necessary if you're going to create this kind of framework. But I think to engender the sort of trust that you'd want to see with this kind of legislation, I think a bit better approach to some of the checks and balances was needed.
Yeah, so Professor, what are some of those harms? I know there's child sexual abuse, terrorism, but and also revenge porn or non-consensual release of of intimate images. But there's also content that foments hatred would be one of these
Mhm.
harms, and incitement to bullying. What can you tell us about? I think we know what we know what child sexual abuse imagery is and terrorism, but what can you
Mhm.
tell us about the bullying aspect in particular? And then maybe I'll have Josh speak on the hate speech aspect.
Sure. So the bullying provision is focused specifically on child bullying. It's not general bullying. And the legislation speaks to that as content that, given the context in which it's communicated, could cause serious harm to a child's physical or mental health, where it's reasonable to suspect that that content has been communicated, and this is important, for the purpose of threatening, intimidating, or humiliating the child. So we're not talking about general bullying. We're only talking about bullying in the context of children, and we're talking with a very specific standard about what that would mean.
Now, Josh, anything you want to add on bullying, or maybe you want to move on to the power of this new proposed regulator to deal with hate speech?
Well, yeah, the hate speech idea, or as the bill puts it, fomenting hatred, is really concerning to me. And that's just because it's very difficult to actually define what is hateful. It's often sort of in the eye of the beholder. And the Supreme Court has tried to define this, and they've come up with a definition, which is actually in this bill. And it's the most extreme manifestations of the emotions captured by the words detestation and vilification. And it's hard to tell exactly what that means. We're told in the 2014 Watcott case that this doesn't include things like disdain, dislike, ridiculing people, belittling people, or merely offensive speech. But it's really hard to know where exactly that line is. And that case told us to look for hallmarks of hatred, and some of these are fairly obvious, but once you start looking at specific examples of things that people do get accused of
Hmm.
as being hateful, it gets
Right.
really hard to know where the line is.
Right.
And just to give a couple quick
Why
examples.
don't we talk about some of the examples after the commercial
Sure.
break? Welcome back to Canadian Justice, where we're discussing the newly introduced Bill C-63, the Online Harms Act. Now, Josh, we were talking about hate speech and how this legislation, through different aspects of it, is designed to address online hate speech. You were giving some examples from the case law of what are called the hallmarks of hatred. And I just wanted you to continue with some of those examples. Like, what exactly would constitute hate speech?
Yeah, and my point is just that it's really hard to know because some of these hallmarks of hatred are, comparing another group to animals, and we can think of examples where most people would agree that's hateful, but there's a lot of stuff that isn't. For example, if there's an extremist religious group that wants to push gay people off of buildings, should somebody who calls that group animals really be facing potential criminal charges or be hauled before a tribunal? Just to give one more example, another example is saying that a group is a powerful menace in society and blaming them for the problems in society. And, you know, that does happen in ways that are very anti Semitic or Islamophobic, but it also is lobbied against white males, for example, in certain DEI training or feminist circles. You might hear that this group is responsible for all of the problems in society. So my main point is just that it's really hard to know where the line is, and when you don't know where the line is, you are likely to self-censor, to silence, and to not participate in debates on controversial topics out of fear of possible prosecution.
Okay, one question I have is so there's criminal code amendments in this piece of legislation, but there's also this digital safety commission. This would not be on a criminal law standard. It's my understanding. So and the criminal law standard is high. So I think one of the things I'm wondering about is, do you think there's a risk, Professor Geist, of content being preemptively removed by these platforms, because there is this sort of perhaps lack of clarity about what might constitute hate speech or what might constitute bullying, especially to the degree that these platforms would almost by necessity need to engage with AI technology to monitor the type of content and respond to takedown requests.
Right. Well, listen, I think content moderation is hard, but I think the reality is that they are taking down or say that they take down many of that kind of content because it already violates their existing site guidelines. And we are not in this context with platforms talking about criminal law provisions or individual liability for anything anyone has said in this context. It is purely a question of the responsibility that the platforms have in dealing with it. The law establishes what's known as a duty to act responsibly, which at its heart is that they've got to try to mitigate against some of these kinds of harms. And that's frankly where all of these harms do fit together. If you believe that all of them are real harms, they already have policies in place to try to deal with it. Is it possible that there is overzealous removal of some of that content in certain circumstances? It's certainly possible, but part of what the law is trying to do is to provide far more transparency associated with developing what some of those standards look like, providing the data on how it is that they handle those things from a process that right now that often can result in removal of content and people don't quite understand why.
So it is not a criminal law penalty, these provisions, but the penalties still are quite high for non-compliance. Josh, what can you tell me about the penalties under the on social media platforms under the proposals for this Digital Safety Commission?
Yeah, so the penalty is $10 million dollars or up to 6% of global revenues, whichever is higher. And, that's going to be, in some senses, a fairly small penalty, but I think it would be enough that they're going to design their content moderation to err on the side of caution. And I think the signal that the government is giving here is that there should be more content taken down, including that content that foments hatred that is currently being taken down. And I think a lot of people look at X or Facebook, and they think in some cases a lot of content things that you should be allowed to say is already being taken down. So that's the big concern here is that the penalties, even though in one sense they're fairly small for a huge company, it's still going to lead to more speech being taken down than should be.
Now, we've only got about 30 seconds, so I'm going to propose this question to you, Professor Geis, and then we'll move to commercial and you can answer it when we come back. But one of the things I've heard concerns about are the broad powers that are going to be given to this safety commission, including powers related to search and disclosure and and the non-requirement for warrants for some of these searches. We've got to go to break, but let's talk about that when we're back. Welcome back to Canadian Justice, where we're discussing the newly introduced Bill C-63, the Online Harms Bill. Now, in the last segment, we were talking about the proposed Digital Safety Commission, this new regulator. One of the concerns I've heard raised about the commission, Professor Geist, is that it's going to have very broad powers of what they can order, including broad search powers. They're going to be empowered to order certain types of disclosure not necessarily even with a warrant, and how this might interact with other international obligations. For example, if a disclosure is being ordered by Canada for material that might be in Europe or something like that, which has very different privacy laws and protections. So, do you share any of these concerns about the broad powers of the commission, proposed powers of the commission, or the search powers?
I have some concerns with the commission. I do think it's important just to, again, back up to recognize that the commission does not regulate individuals here. The commission is regulating platforms, and the penalties don't apply to individuals. Penalties apply to platforms. So this is all about the interaction between the commission and the large platforms themselves. I must admit, I don't really see the government encouraging takedowns. In fact, if anything, their earlier proposals envisioned far more taking down and removal of content than this one does. They've actually backtracked almost completely on some of those prior proposals to remove content. Where I think there are problems, though, is in that oversight. If there is going to be trust and confidence in this system, I think you have to ensure that there may be a need for some of these powers, but there's got to be appropriate oversight as part of it. And there, I think there are real concerns. For example, there aren't even specific rules of evidence. In fact, the government wants this commission to be able to move expeditiously and perhaps even informally. That seems to me to be pretty inconsistent with some of the powers you articulated, or the kinds of penalties that Josh mentioned with respect to those large platforms. So I think if there's going to be, and there needs to be some way to enforce these rules, but there's got to be a mechanism to ensure that there is appropriate oversight and limitations there. Not sure that the government struck the right balance, at least at the start, in terms of how this commission would function.
Yeah, and of course, this is proposed legislation, so there may be changes at the committee stage or as this legislation progresses through Parliament. Now, Josh, as Professor Geis mentioned, these are not about penalties for individuals when we're talking about the Digital Safety Commission, but the legislation does propose penalties for individuals for speech in amendments to the Criminal Code and in amendments to the Canadian Human Rights Act, or at least the potential for penalties. Why don't you tell us first about the proposed changes in this law to the Criminal Code?
Yeah, so there would be two new provisions of the criminal code that are quite concerning to us. One of them is a provision that is called fear of hate propaganda or hate crime. And this is a provision that would allow a person or a group that thinks somebody is going to commit a crime, like, for example, inciting hatred, to go to the Attorney General and get permission to lay in information before a judge to try and prevent this from happening. So, for example, somebody might be planning a rally where they're going to talk about gender ideology, and maybe people fear they're going to say something that's transphobic hate speech. A group could go to a judge and ask them to put restrictions on this person to prevent this speech from taking place. And these are pretty severe liberty limiting restrictions, like, a curfew or an ankle bracelet, or agreeing not to go to a particular place. And if you don't agree to these provisions, then you could potentially go to jail. And the second criminal provision that this is introducing, is a standalone hate motivated crime provision. So any other provision of any other act, like the criminal code or another act of parliament, if you're charged with a crime or something under one of those acts, you could also be charged with hate motivation. And the scary thing about this is that it has a potential life sentence. And so let's say you commit a crime like mischief, or you're accused of something like vandalism, and this also gets tacked on. It's a separate crime that you could be convicted of. And the big fear with that one is that, people facing this potential life sentence, which they're unlikely to get, are still going to be faced with, bad plea deals and pressured into taking plea deals that they wouldn't otherwise take because of the fear of that very severe potential sentence. And so those are the criminal ones. I can also just briefly explain the civil penalties. So this is bringing back Section 13 of the Canadian Human Rights Act, and this is where individuals or groups could see somebody committing potential hate speech or
Yeah.
discriminatory speech online
And
and
then they
take
report
somebody
it
to
to the Canadian Human
a
Rights
tribunal.
Commission. So
Yeah.
I want to do a deeper dive into that when we come back from commercial break, because I think this is an important aspect of the law. Welcome back to Canadian Justice, where we're discussing Bill C-63, the newly proposed online harms bill. And I wanted to follow up, Josh, on this proposal to amendments to the Canadian Human Rights Act. It proposes a reintroduction of Section 13 of that act, which is a civil remedy for hate speech. Members of the public can complain to the Canadian Human Rights Commission about hate speech they may see. I'm not sure if it's limited to online, but certainly applies to online hate speech. And then the commission does an investigation. Why don't you tell me about maybe some of the history of that provision of the Canada Human Rights Act and what this new proposal is bringing in?
Yeah, so Section 13 has always been fairly controversial. And basically, it predates the internet. So back in the day, it was, people who would hand out cards where you'd call a number and you'd get anti-Semitic messages at the other end of the phone line. Or in some cases, you would print articles in newspapers, and those would catch the attention of people that felt they were discriminatory. And where the Canadian public really sort of turned on Section 13 was when certain groups started going after journalists for articles that they had published that they were accused of, um, fomenting Islamophobia or certain kinds of hatred against homosexuals, things like this. And Mark Stein, who was a writer for Maclean's magazine, he published an article called "The Future Belongs to Islam." And that particular case got the attention of a lot of people because there was a potential that Stein would have to pay a fine, or that Maclean's would have to publish an article in response to this claim that his article, which was on a topic of public interest, was discriminatory. And so that provision was removed by Parliament about a decade ago. It was reintroduced, or proposed to be reintroduced in Bill C-36 in 2021. And now it's back. It's back in C-63, and it could potentially become law again. And this is a big problem again for chilling speech, because people don't know where the line is, but there's potential that you could be hauled before the commission and have to defend your speech. And if you lose, you might have to pay damages of up to $20,000 or fines of up to $50,000. And just having to go through that process is sort of punishment itself.
Yeah, I
So
think even
that's
if you
that's the
don't
history.
get to the tribunal stage, many people, I think, the stories that you were describing earlier, I know that when those individuals went through the inquiry, the investigation process, I mean, they retained counsel. They're incurring costs associated with an investigation, even though in those cases it never made it to the tribunal. Professor Geist, what are your views on these proposed changes to the Canada Human Rights Act? Do you share any of those concerns?
Yeah, and I think those concerns are legitimate. I think the Section 13 is a slightly different Section 13, and it is narrowed from what was previously there. But so, and perhaps that will have some impact in lessening it. But on the whole, I think that the government, to its credit, had really crafted a much improved approach from what it had previously proposed with respect to the internet platforms. And that in many ways was really what we were being
Improved
sold.
on top of the earlier proposal in 2021, you mean?
Exactly.
Yeah.
So what they had in mind, and frankly, the approaches they had taken with some of the other bills we've talked about in prior shows around Bill C-11, the streaming bill, and the news bill C-18, is a dramatically, I think, improved one, where they genuinely, I think, listened to a lot of experts and tried to come up with something on the platform regulation piece of dealing with harms, which is where I think there was a recognized need to address the issue. They did a better job. The inclusion of the criminal code and the Human Rights Act provisions, frankly, I recognize that it's all part of a piece in dealing with harms, but I think that it becomes a significant distraction and raises real concerns. I mean, it's clear we spent about half the episode talking about what is relatively small part of an overall large bill, and I understand why, because it raises those kinds of concerns.
Hmm.
Frankly, I think given the import of dealing with some of the online harms, the government would be better off and would have
Right.
been better off to have put that, if they want to move forward with something like that, in a separate bill where it
Right.
can be properly debated
That's
rather than included this way.
that's all the time we have. I want to thank you both for coming on.
Thank you.
We've heard today about the newly introduced online harms bill. This bill does many things, things that, to be frank, are unrelated to one another. There are serious concerns from many civil libertarians, myself included, that the bill in its current form is unconstitutional. What do you think? What makes you most concerned about this bill? Will it lead to censorship? You be the judge. Thanks for watching, and remember, a freer Canada starts with you.